हाय एवरीवन। इस लेक्चर में हम बात करेंगे प्रीएम्बल टू द कॉन्स्टिट्यूशन, वेयर मीनिंग, contents, its use and its interpretation by the Supreme Court. So preamble basically is an introductory statement जो हर किसी statute या law के से related attach की जाती है और जो क्लैरिफाई करती है इसका ऑब्जेक्ट पर्पस ऑफ एवरी law and constitution, so that illustrates the intention of the drafters of the constitution or of the law or enactment. So please subscribe to the channel and comment on the videos. If there are any gaps, please do mention in the comment section. So अगर हम मीनिंग देखें प्रियम्बल का तो और पर्पसेस देखें, सो बेसिकली प्रियम्बल जो है एक स्टैट्यूट को और इट क्लैरिफाइज कि किसने कॉन्स्टिट्यूशन को बनाया है, who has made the constitution. Secondly, it contains the enacting clause, like people have adopted themselves like that. Thirdly, it talks about what is the source of the constitution. If we will look into the uh, preamble of the constitution and constitution of India, the people are the source of the constitution. It contains the fundamentals of the constitution. It talks about or contains rights and freedoms of citizens. It talks about what kind of polity that nation is having. So basically, if we will look into the purpose of preamble, so these are the basics. And apart from this, preamble doesn't grant any power, but it gives a direction and uh, purposes to the constitution. So basically, it contains all the fundamentals of the constitution. And apart from that, its basic socio-political object. So अगर हम देखें कि जो first objective resolution was introduced by Jawaharlal Nehru on 13th of December 1946. So इस draft में Jawaharlal Nehru proposed this very objective resolution consisting of 7 paragraphs. So basically it was talking about the basic objectives that a constitution and free India needs to sort. So 42nd, then Constituent Assembly 22nd Jan 1947 को इस ड्राफ्ट को अडॉप्ट किया. अगर हम जो करंट जो इसका प्रीएम्बल का स्ट्रक्चर देखेंगे, that was actually prepared or drafted by the drafting committee in February 1948. That was actually in consonance with और जो मतलब जो objective resolution जवाहरलाल नेहरू ने propose किया था उसके spirit में था. So before going into the contents of preamble, let's have a reading. It reads as, we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice that will be social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, and to promote among them all fraternity, assuring dignity of an individual and unity and integrity of nation. So in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this constitution. So basically the last is the enacting clause that talks about the ultimate source and power of the constitution. अगर हम देखें कि जो USA और higher constitutions हैं, those constitutions are opening with the statement we the people. So in the same way, Constitution of India की जो preamble है that opens with we the people of India. अगर हम इस चीज को देखें तो actually it talks about and propounds theory of sovereignty that lies in the people, that shows that this preamble, this constitution has been drafted by the people of India and they themselves adopted it. इस चीज के इसको किसी और एक्सटर्नल फोर्स ने नहीं वो किया, बनाया या इम्पोज किया. सो उषा भारती वर्सेस यूनियन ऑफ इंडिया में सुप्रीम कोर्ट ने बोला कि द फ्रेज मेक the phrase we the people makes it very clear that people are supreme, not elected representatives. So when if we will talk about its importance, so Jawaharlal Nehru said that preamble of India का जो preamble है वो states या फिर group of states, people of states नहीं बनाया गया. It's people of India जो उसकी मतलब इंटीग्रिटी या फिर एक वननेस को represent करता है. The people in entirety adopted that and they are not supposed to secede from the Union of India. So another issue comes in picture, whether preamble is a part of the constitution or not. Can it be amended or not? So for the first time in Re-Beriberi Union and Exchange of Enclaves case that was decided by Supreme Court in 1960s, court said that preamble is not a part of the constitution. So here the word re shows the meaning that is actually under article 143. The President of India can seek opinion from the Supreme Court. So re talks about in reference to, in context of. So Article 143 states that there shall be at least there shall be 5 judges to respond or to decide on the advisory opinion. So for the then in Keshwananda Bharti versus State of Kerala in 1973, Supreme Court said that preamble is an integral part of the constitution because in the Re-Beriberi Union case, the point was missed that preamble has also been adopted and enacted in the same way as the constitution itself. So it forms the part of the constitution, and secondly, it can be amended as well under Article 368, but it is subject to basic structure doctrine. There is a limitation. So when we are talking about the objectives which are enshrined in the preamble of the constitution, so things can be added, goals can be added, but nothing can be deleted or to do away with. So for the first time, the constitution 42nd amendment was made in 1976 when socialist, secular and integrity, these 3 words were added into the preamble. In 1979, Supreme Court said when they are talking about the word socialist, so they said that it must enable the courts to lean towards nationalization and state ownership. Like there must be a fair balance between public and private ownership. It is not like that private ownership should overcome the state ownership. So there must be a fair balance so that society can go ahead. So another case, that is DS Nakra versus Union of India, that was decided in 1983. So basically in this case, we can say socialism means distributive justice, so that it can bring about distribution of material resources, and even it can provide a decent standard of life to the people from security from cradle to grave, so that human dignity can be maintained. Apart from that, there is a case that is GB Pant University versus State of UP that is decided in 2000. So in Supreme Court talking about that democratic socialism actually aims at eradication of poverty, ignorance, disease, and inequalities of opportunities that are actually embedded in the society due to uh, untouchability, casteism, because the India is a casteism, caste-ridden society. So all those things needs to be to do away. So another case that was important, Smatha versus State of Andhra Pradesh. It's a case of 1997. So when they're talking about socialism and all, and talking about bringing equality of status among the people, the court said that articles like 14, 15, 16, 17, 21, 38, 39, 46 must be read in consonance, and it must be aiming at reducing inequalities in income and social status, because if the people will be getting in good economic standards and will be getting equal pay, then their social status will be automatically uh, upheld. Then another word is there that is inserted by 42nd Amendment, secular. So though secular word was very much embedded in the constitution itself, it's not a new to the constitution, but just to strengthen the secular part of the nation and to elaborate it as a very important goal, they inserted by 42nd Amendment in the preamble as well. So secular shows here means state has no religion. Neither state is going to promote any religion, nor it is going against any religion. It will be neutral. So that has been actually held in State Xavier College versus State of Gujarat. So in St. Xavier College versus State of Gujarat in 1974, Supreme Court said that secularism is neither anti-God nor pro-God. And another important judgment in case of secularism came into 1994, SR Bommai versus Union of India, where Supreme Court said that secularism is a basic feature of the Constitution, which cannot be eliminated from the Constitution, and it is required to maintain the fair balanced society. So another judgment delivered by Supreme Court to promote the secularism and to bring egalitarian society was Paul versus Cochin University. In 1996, Supreme Court said that intercaste marriage and adoption, these are the two institutions through which secularism finds its way, and it helps to establish an egalitarian society. So Aruna Roy versus Union of India 2002 Supreme Court said कि जो वैल्यू बेस्ड एजुकेशन है दैट इज एक्चुअली वेरी मच रिक्वायर्ड एक एगेलिटेरियन सोसाइटी एस्टेब्लिश करने के लिए. So for that it is required all the teachings of all the religions are required to be taught, but it doesn't mean that okay schools or states will take just one religion as a basis of education and to promoting value-based education. So all the principles, all the teachings which are promoting equality, which are preaching human dignity needs to be taught. So another word is democracy. Democracy means rule by the people. अगर हम देखें कि जो डेमोक्रेसी है वो ओरिजिनेट हुई है ग्रीक वर्ड से डिमोस that means people and kratos means authority. So authority of the people. Abraham Lincoln said democracy means uh, democracy by the people, of the people, and for the people. So where democracy means there's a representative government, there will be people will be elected directly or indirectly, right? So in Mohanlal versus Mohanlal Tripathi versus District Magistrate Raebareli, It's a case of 1993. Supreme Court said democracy is a concept that is a kind of political philosophy, which actually an ideal practiced by many nations that are culturally advanced or politically mature by reasoning to governance by representatives of the people, elected directly or indirectly. अगर हम डायरेक्ट डेमोक्रेसी का देखें तो स्विट्जरलैंड इज एग्जांपल ऑफ डायरेक्ट डेमोक्रेसी. Indirect democracy is India, that where MPs and MLAs are and president are elected through indirect elections. So it has adopted universal adult suffrage. Article 326 provides right, that is a constitutional right, uh, uh, to every person who is of 18 years age to cast a vote. So signifying the rule of law, Supreme Court in Mahinder Singh Gill versus Chief Election Commissioner in 1978 said that free and fair elections are very important for a democratic country, so that rule of law can be maintained and representative can fairly talk about its goals and promote and legislate for the welfare of the people. So another concept is republic. It actually incorporated or included in the preamble, in contrary to monarchy. Here जो रिपब्लिक हेड जो है वो स्टेट का इलेक्टेड है बाय द पीपल, इट्स नॉट हेरिडिटरी, एंड वो एक फिक्स टर्म के लिए जो इलेक्ट किया जाता है, बट जो फाइनल से है, फाइनल पावर है, दैट इज वेस्टेड इन द पीपल. So another word is sovereign, that we have already talked about, that concept or the phrase we the people of India talks about and propounds a theory of sovereignty. But if we look into this particular phrase, it seems that it has been adopted from the Article 5 of the Constitution of Ireland. So India is a sovereign, it is free from external powers, it can make its decision of its own, so it is internally as well as externally free. So far as concept of sovereignty is concerned, I'll be discussing in a different lecture. So if we will look into the concept of justice, so actually justice is the harmonious reconcilement of an individual conduct with the general welfare of society. So basically it's an act or conduct of a person is said to be just if it promotes the general well-being of the community. So therefore the attainment of the common good as distinguished from the good of individuals is the essence of justice. So there are three kinds of justice that preamble aims to achieve, constitution aims to achieve, that is social, economic and political. Social justice, because India is a caste-ridden society, there are a number of communities, culturally, religiously diverse, so there must be some harmonization, and apart from that it aims to eradicate uh, all kinds of inequalities which may result from the inequalities of wealth, opportunity, status, race, religion, caste, title, and the like. So, to achieve these very social justice, uh, Part 4th of the Constitution, Direct Principles of State Policy, elaborates number of principles that needs to be taken care. जब एक state law बनाएगी, तो then they will be looking into all the directive principles of state policy so that a gap can be filled and जो लोगों का social status है, एक dignity है जो maintain की जा सके. So there are a number of provisions, especially Article 38 of the Constitution talks about promotion of social order and social justice. So in Air India Statutory Corporation versus United Labour Union. It was actually a case of related to the Contract Labor Regulation and Abolition Act 1970. So basically, the court said that Preamble and Article 38 needs to be read in such a way, and state must ensure कि जो ह्यूमन डिग्निटी है वो मेंटेन रह सके और पीपल की जो इकोनॉमिक एंड सोशल इनइक्वालिटीज है वो टू डू की जा सके सो जो कॉन्ट्रैक्ट लेबर है या फिर जो बेकार है उसको खत्म किया जा सके देन ओनली जो अनटचेबिलिटी है आर्टिकल अंडर आर्टिकल 17 वो एलिमिनेट की जा सकती है then second form of justice is economic justice. Actually, basically, the economic justice means to provide equal opportunities to all the people as enshrined under Article 15 and 16. And it focuses on elimination of economic inequalities. And apart from that, for that, it requires people should get equal pay for equal work. Only then this is possible to achieve. So Article 39D talks about equal pay for equal work and equal opportunities for men and women in matters of work. And Article 42 talks about humane conditions of work. So all these things are required, and these things has been discussed by Supreme Court in Ranveer Singh versus Union of India. So another as a political justice. Political justice aims at to promote the democratic setup, democracy in the country. So that is only possible if all the people will be given equal opportunity to vote and elect the government, so that a fair balance of decision making and participation in elections can be done. So and that was actually decided in Minerva Mills Limited versus Union of India. That is a case of 1980s. So there are three other concepts: liberty, equality, and fraternity. So liberty of thought, expression, belief, faith, and worship. There are two kinds of liberty, like rights, negative and positive. Negative liberty means a person is entirely free. There are no restraints like freedom of thought and expression, but it is though subject to some conditions, subject to some limitations. And positive, like there is certain control of the state, their state can say something. So these liberties have been included in Article 19 and Article 25 to 28. So the conditions are like in the form of morality, public health, and all. So equality of status and opportunity, that is that we have already discussed, that Article 14, 15, 16, 17, these are talking about promoting the social equality. So talking about the fraternity, because India is a country of diverse communities, religions, cultures. So it has been dealt in Volsama Paul versus Cochin University, where Supreme Court said social democracy means a way of life which recognizes liberty, equality, and fraternity as a principle of life. And apart from that, they are not separate items in the Trinity, but they form union of Trinity. So to diversify one from or divorced, one cannot be divorced from each. If it will be done, तो जो पर्पस है डेमोक्रेसी का वो फेल हो जाएगा. So without equality, liberty wouldn't produce uh, would produce the supremacy of the few over the many. So equality without liberty would kill individual initiative. If people will not be given equality, so obviously there will be no individual initiatives. There will be a coercive regime. So without fraternity, liberty, and equality could not become a natural course of things. So the lecture on the preamble shows the basic contents. So thank you. Please subscribe to the channel, comment on the video, And in the next lecture, I'll be dealing with from Article 1 to 4. Thank you.